Thanks for coming out again. I say that every time, but that's only because I have to say it. And you have to be here. Thanks. And this is an introduction to international law. Now, as you've been reading the first few chapters of this book, it's very dense. So I want to begin with, what is international law? And the easy answer to that question is, I have no idea. And neither does anyone else, because it's extremely ambiguous. I mean, initially it was only the nation states that had legal personality. In fact, do we even have to listen to international law? And the question is no, but we do. And that's what makes it so ironic and so interesting to study. A lot of people say, it doesn't really matter. We live in a state of anarchy, like realists, etc. But people do. They do actually listen and heed to it, and they do try to persuade people in the international community that they're correct. Why did George Bush, for the Iraq War? Now, I know as time goes on, unfortunately, I'm getting older and you people are getting younger. Really, you're staying the same age, but I'm just getting older, and this is history now. But George Bush went to the Security Council, the United Nations, Colin Powell went in, look at this. This is evidence that Saddam Hussein had weapons of mass destruction. Why? Because he cared what the international system thought. He knew he didn't have the Security Council votes, but at the same time, he wanted to convince the world. So it does matter in the sense people want, and then states want, because states are people, legitimacy. So it does matter. Moreover, there's something in the book on reciprocity. This is very, very important because that's one of the strengths of international law, according to the book. So what does that mean? Well, reciprocity is a good idea to start with international law, because a lot of developing countries actually heed the call of international law. In the case that you see the video on Chile and Peru, they were literally going to have to get police when the ICJ gave its ruling on whether Peru would get land that was lost by Chile centuries ago. So the question is, why is it so important? Developing countries do listen to international law more. And that's very important because they might have to. It's true, the UK, the United States, I keep on talking about the Nicaraguan case where the United States didn't listen to it. It's completely true. But the thing is that most countries are developing countries. And in that video, you see that, there is this idea of reciprocity. States actually have to listen to the International Court of Justice because it's in their long-term interest, like a small country like Peru. I mean, I'm not saying it's small if you're from that country. Same thing when Bolivia took Chile, took to court to get access to the sea, which it lost earlier in early South American wars. This is very, very important to them, and they actually listen to this, and many actually heed the call. And that's very important to understand. I mentioned before when Argentina took Ghana to court over holding its warship, which was being pressured by international hedge funds and others to get their money back. They're called vulture funds. So Ghana was holding an Argentinian warship, military ship, and then Argentina took Ghana to the International Court of the Sea, which I want to say is in Hamburg. I know my German is very bad, Germany, and then Argentina won and Ghana let the ship go. So smaller countries actually do heed that. And when you see that very short video, you see, they were like, oh, we better have more police on patrol in case people get violent after the ICJ ruling. It's like, who listens to an ICJ, that's difficult to say, ruling, in the United States, UK? I'm not saying they never do, but it is interesting to see in developing countries they do. And that's all about reciprocity. They're very nervous about the fallout of these court cases because they do heed the call. I know Latin America a little better, but it's same with Africa, Cambodia versus Vietnam, over fishing rights, etc. And I really want to talk about, if like I began with talking about how international law is ambiguous, which it is. I mean, you look at the protests behind me, they've been, but they're not legal personality. These people, this is in Colombia, where they were fighting to get their land back. As you may know, that we started a huge process of defoliage in Colombian hinterlands in order to stop them from growing coca. But a lot of the people just grow coca because that's one profitable. They're told grow profitable drugs, so they grow cocaine, and they were promised other land, other crops, etc. And the government never really address the issue that would be satisfactory, at least in a certain manner for these people. So they're out protesting, but in international law, do they have legal personality? And that's going to be very, very important, because international law really started with the nation state system. And those are the entities that have legal personality that are included in international law, whereas many other non-state actors, human rights activists, etc., are excluded. But we're going to talk about that even a little more. But where does international law come from? Unlike our laws, it's very, very different. We have the executive, the legislature, the judicial branches, particularly United States in our law. But in the law of international law, you have it's customary. It's basically based on the practice of states. That's one of the things that the book talks about, and I think it does a great job at understanding that this is what makes state behavior so important. So when Israel bombed, I want to say it was around 1982, Ozark alleged nuclear power plant in Iraq. That was for a preemptive strike. We did the same thing with Iraq, over 20 years later. And does this kind of set a precedent, a customary law practice? And this is what made a lot of international lawyers nervous with the Iraq war, is that it was a preemptive war. And does that make preemptive war part of customary and law and basically practice of states? And that becomes kind of nerve-wracking and anxiety inducing, because then anyone can just say, oh, well, this country was going to do this, therefore I had to preempt it and I had to go to war. And that's not how war, or at least force, is supposed to be used in it. You also have treaties, which are very important. But then when we get into that chapter, because I know a lot about treaties, particularly in Latin America, a lot of treaties are written when developing countries have dictatorships and they have no other choice, and the people have to kind of swallow these treaties that they don't accept. But treaties are important. They establish an obligatory reciprocity between states. NAFTA, CAFTA are treaties, and we're going to see something on that when we get to the treaty stage, but that's very, very important. We have other issues such as writers, people who actually write in international law. ASU has a law school. They actually do peer-reviewed writings, and that's very, very important. But I think one of the other things is cases. These set precedents, not just customary law and practice, but actual court cases. So when you look at the case that's going on between Chile and Peru, what is the International Court of Justice thinking about this? And what is its ruling? And then I gave a supplemental small article on that if you are interested in that particular case. Remember, the final paper is a case in international law you have to deal with. All that is on the syllabus. And, for our Zoom meetings, you're welcome to ask more questions on that. But remember, international law is different. It's basically, based on customs, practices of states, writers, precedent, particularly court cases, are very, very important to international law. And the idea of legal personality, who's included and who's excluded in international law, is very, very important for a wide range of people. So if you want to go into international law, you have to consider that there is a limited amount of legal personality, although that has been expanding. Consider it. You also have different theories. Realism has been a theory since the end of World War I, and that it basically stresses the role of anarchy, that there is no police force. So as the book states, consent is very, very big in international law. And that's very important, because consent is a little different than being forced. If I do something illegal, right, I go out, I mug someone, and then the cops ransack my house and drag me out, that's not my consent. I'm being forced to, because we have a police force. But in a state of anarchy, there is no international police force. And the idea of getting one is very, very controversial. because states are very nationalistic. They don't want their troops, particularly the United States. And this happened when we were bombing the former Yugoslavia, when we accused Serbia of committing atrocities like genocide in Bosnia and Herzegovina, that U.S. troops were under their blue helmets. All that discourse, if you're old enough to remember, came out. So states don't want their troops to be under the United Nations necessarily. And the fact is, there is no police force, as we saw in Rwanda, as we see now in Myanmar, which is a debate which I think is an amazing but yet lamentable subject of international law. So consent is important, but I want to stress that a lot of states do consent to international law because they see it maybe not in their short-term interest, but their long-term interest, and they have more at stake in the international system, particularly developing countries who do heed the call often of international law. Just because the United States might marginalize and exclude international law, as well as the UK and bigger states, it doesn't mean smaller states. And it is very important, as I keep on saying, international law allows smaller states like Nicaragua, in that case, very important, to rewrite history and have it on the books of what happened. And, as we know, history, ontologically speaking, is written by the winners. And in this case, maybe the smaller, poorer countries, I mean, remember, Nicaragua is the smallest country and the poorest country in Latin America, in Haiti, and it took the United States to the International Court of Justice and won in the 1980s. So thanks for listening, everyone, and take care out there. And I look forward to the few Zoom meetings we do have, and reach out to me anytime you want to speak about something. I really enjoy engaging students, particularly under these unprecedented COVID conditions. Take care, everyone.